Hello YouTube, welcome to the second episode of Know Your Law, and on today's episode we'll be covering the topic of theft. We're going to look at the definition of theft, we're going to look at the elements that constitute the crime of theft, and lastly some of the criticism of those elements. So let's get into the video. So for the definition of theft, we can get this from section 1 subsection 1 of the Theft Act 1968, which says a person is guilty of theft if they dishonestly appropriate property belonging to another with the intention to permanently deprive them of it. Now, to find someone guilty of a crime, any sort of crime, not just theft, you need to satisfy two things. Firstly, that they've committed the physical act of the crime, and secondly, that they have the prerequisite mental element, so whether they intended to commit the crime or not. We can do that with theft here, and it will allow us to nicely segment the video into two separate sections. The first section will look at the act, comprised of three parts. That's the appropriation, property, and belonging to another. And the second section will look at the mental element, two parts, the intention to permanently deprive and the element of dishonesty. So we're going to look firstly at the act. Let's get into that. So for the first part of the act, we have appropriation, and there are a few cases here we can use to define this concept. The first case is Pitton versus Hell from 1977, which says that an appropriation is an assumption of the rights of the owner, so treating the property as if it's yours to use or dispose of. We have Morris from 1984 that says an assumption of the owner's rights must be more than a mere touch. So it has to be something a bit more permanent. It can't be too temporary. For example, if I was to touch this piece of paper here, that wouldn't be an appropriation. It's too temporary. I need to take it for myself. We have the case of Lawrence versus Met Police Commissioner from 1972, which says that you can appropriate even with the consent of the owner, and Rader from 1992 that says you can appropriate even with the full consent of the owner, not just the implied consent. Now, if that's a bit confusing to you, how can you appropriate for the purposes of theft, even if you have the owner's consent? I think it's more revolves around the concept of dishonesty, which we will explore later, and really how you're dealing with the other person, whether you're dishonest in obtaining that property and how you intend to use it. We also have the case of Gomez from 1993, which says that you can appropriate a gift, and this was expanded upon with R.V. Hinks in 2000 that says even if ownership of the property has completely passed from the previous owner to the current owner, it can still be appropriated, and that was confirmed by Wheatley in 2006. In the cases of gifts, when you transfer a gift, you're transferring the entire ownership of the property to another person. The reason we have this idea that you can appropriate a gift, and you think even if you hand a gift over to someone, there's no way you can steal it. It's really there to protect vulnerable people who may be giving out valuable items, money, jewelry, etc. To other people, and they might not really understand exactly what they're doing. So that's why we have that sort of provision in the case law. Lastly, for appropriation, we have Section 3, subsection 2 of the Theft Act, which is the bona fide purchasers exception. And what this means is if you purchase in good faith with no knowledge that the property was stolen, then you cannot be said to be assuming the rights of the owner. So there'll be no appropriation in that specific context. So that's appropriation. So let's move on to property. So in this section, we are going to look at what does and what does not constitute property for the purposes of theft. We look firstly at Section 4, subsection 1 of the Theft Act, which says property can include money, real property, which is land and everything attached to it, and personal property, so all property that is not real property, possessions such as books, paintings, jewelry, phones, etc., that sort of stuff. We have the case of Chan Man-sin versus Attorney General of Hong Kong, 1988, which says that you can be guilty of theft of what the law calls a chose-in action. What this is basically an intangible property right, a right that exists in something you cannot hold physically, but it's otherwise enforceable. In this case, it was a bank account. We have Oxo versus Moss from 1979, which says that the confidential information in an exam paper was not held to be property for the purposes of theft. Now, just as a slight caveat, the misuse or mishandling of private or confidential information can be subject to action in civil law under doctrines such as breach of confidence or misuse of private information. Just a little bit of advice there. We have the case of Lowe versus Blease from 1975. Electricity is not property for the purposes of theft. Sharp from 1857. A corpse stolen from a cemetery is not property for the purposes of theft. However, in R.V. Kelly 1999, it was said that whilst stealing a corpse, a whole corpse is not considered property, the corpse or parts of it can become property by application of skill such as medical use or dissection. And the Human Tissue Act of 2004 creates a new offence of DNA theft. We also have a few exceptions coming from the statute. Section 4, subsection 2 of the Theft Act concerns land. In general, land cannot be stolen unless you already have the power to use or dispose of the land. So if you're a trustee or an owner of part of the land. Section 4, subsection 3 is wild growth, so plants, mushrooms, flowers, that sort of thing, generally cannot be stolen or considered property unless used for commercial purpose. And lastly, section 4, subsection 4, which concerns animals. Tamed or untamed animals can be stolen, but you generally cannot steal what is not ordinarily kept in possession. So if it's something like a dog or a cat, which is quite a common pet, you can be guilty of theft of those. But if it's something a little bit more exotic or rare, such as, I don't know, a skunk, for example, then you would not be guilty of theft of that animal unless that individual animal was already brought into possession by an owner. So that sums up property, and now we're going to move on to the last part of the Act, which is belonging to another. So for the aspect of belonging to another, we look firstly at Section 5 Sub 1 of the Theft Act that says property belongs to another if they have control, possession or a proprietary interest in that property. What proprietary interest is basically some sort of legal right to own, use or dispose of the property. We have the case of Dyke and Monroe from 2002. Here, a defendant had stolen from a charity box but was charged with stealing from the public, and the conviction was quashed because the ownership of the money had passed to the charity. We also have the case of Turner, number 2 from 1971. In this case, a man had left his car in a garage but had gone back later to take his car from the garage before the repairs were done, and he was actually guilty of stealing his own car. The reason being is at the time when the car was in the garage, it was under the garage's temporary ownership and possession. We also have Section 5 Sub 3, the idea of receiving property under obligation. We have the case of Rostron and Collinson from 2003. In this case, some golfers had taken golf balls that were abandoned on the course. However, they were guilty of theft of those because the property of the golf balls had actually belonged to the golf course and there was an obligation to return them to the golf course owners. We also have Davidge against Bunnett from 1984. In this case, a flatmate was given money to pay for the gas bill but had instead used that money to buy other stuff and was guilty of theft because the property, so the money, was received under obligation and it was misused. We also have Section 5 subsection 4, the idea of receiving property by mistake. So we have one case here, Attorney General's reference number 1 of 1983. In this case, a defendant was overpaid wages, had noticed that she had been overpaid, but did not withdraw the money. Although not convicted of theft, it was said that in these types of situations where you're overpaid, there is an obligation to restore the overpaid money to the employer, and if not, could be guilty of theft. However, take that wording carefully, there has to be a legal obligation to restore, and this is the case of Gilks from 1972, in which a defendant had gone to a bookies, gave a betting slip in, and the bookmaker overpaid on the betting slip. However, in this case, it was decided that betting transaction was not legally enforceable because the ownership had passed entirely over to the defendant. So there's no conviction of theft in that case. So that sums up belonging to another, and that also sums up the entirety of the act of theft. We've looked at appropriation, we've looked at appropriation with consent and appropriation of a gift. We've looked at some of the things that encapsulate what property is, and we've also looked just now at what belonging to another constitutes. And as a result, we're now going to move on to part 2, which is the mental element, covering dishonesty and the intention to permanently deprive. So let's move into that section now. So for the first part of the mental element of theft, we're going to look at dishonesty. Now, the Theft Act doesn't actually define what dishonesty is or what constitutes dishonest conduct, but does give 3 situations in which a person is not dishonest. And these 3 are found under section 2 sub 1, and they are where the defendant has the right in law to deprive the other person, where the defendant would have had the other person's consent had they known about it, and lastly, the owner cannot be found by taking reasonable steps. So we're going to look at a few cases under these headings right now. The first, under right in law to deprive, we have the case of R.V. Wootton and Peake from 1990. In this case, the defendant had taken some items from the employer in advance of some unpaid wages. And it was held that the defendant was not being dishonest because of a prior arrangement where the employer would actually pay the employees with some items as substitute for wages. And because of that understanding and that arrangement, it was held that they did have the right in law to deprive the employer and were therefore not being dishonest. Contrast that with the case of Forrester from 1992. In this case, a defendant had entered a property which he previously rented and demanded money back from a deposit from the landlord. He started taking some items in order to force the landlord to pay back on that deposit, but was held to have been dishonest because he knew he did not have a right in law to deprive the landlord of those items, was therefore guilty of theft. For the issue of whether they would have had the other person's consent or not, we have the case of Flynn from 1970. Here, a defendant had taken some money from the employer, from the company that he was working for, in advance of unpaid wages. However, in this situation, it was held that the company would not have agreed to have their property, which is the money, being taken from them, and therefore the defendant was being dishonest. And lastly, we have the concept of whether or not the owner can be found. This is the case of R.V. Small from 1987. In this case, the defendant had taken a car which was abandoned. There was evidence that it was abandoned, and therefore his theft conviction was quashed. So now we actually look at what does constitute dishonest conduct, and we look to the case law for this. The first case is Feely from 1973, which says that dishonesty should be measured by the standards of ordinary people. And we'll come back to this concept shortly. The main test for dishonest conduct is the case of R.V. Gosh from 1982, and this is now known as the Gosh test. This is a 2-part test to determine whether or not the defendant has been dishonest in their conduct. The first part of the test is an objective test. You try and set an objective standard to which you measure the defendant's conduct. And this is generally called, if you look this up, if you research it, it would usually be called the reasonable man or reasonable person test. You try and set like a benchmark. And then the second part of the test is the subjective test, where you look at whether or not the defendant believed they were dishonest in relation to the standards you set from the first part. And we'll come back to this later on because there are quite a lot of criticisms on the Gosh test. But that sums up dishonesty. So we've looked at what is dishonest and what isn't dishonest, and we've looked at the test as well just now. And now we're going to move on to the intention to permanently deprive. So for the second part of the mental element, we look at the intention to permanently deprive. And this basically means treating the property as yours to use or dispose of regardless of the owner's rights. And again, we have a few cases here to look at. The first is R.V. Vellamil from 1989. Here, a defendant had taken banknotes from an office safe, had intended to replace them, but was still guilty of theft. The reason being is the defendant would not be replacing the exact same banknotes and was therefore held to permanently deprive the office of those specific banknotes. We also have DPP against Lavender from 1994. Here, a defendant had taken some doors from properties with the intention to replace the doors on someone else's property, but was guilty of theft because he was intending to permanently deprive the council of their property, the doors. We also have this small concept of borrowing. So this is the case of Lloyd from 1985. Here, a cinema projectionist had lent a film out to the defendant who copied it, but had returned it in time for the next showing. And the defendant was not guilty of theft because he had not intended to permanently deprive them of that property because he had returned it. So that sums up the mental element of theft. We've looked at dishonesty and intention to permanently deprive, and that sums up the whole topic of theft. We've looked at the act and the mental element, and now we're going to move on to some of the criticisms of aspects of the law of theft. So let's move on to that. So for this last part of the video, we're going to look at the criticisms and some of the issues with the law of theft. And we're going to start with the Gosh test. Now, both parts of the Gosh test have problems associated with them. Firstly, when we look at the objective element, we look at obtaining a standard of the ordinary reasonable person by which we judge the defendant's conduct to. But who is to say what is ordinary or average or the reasonable person in this case? It's very difficult to define that concept, especially in a society with wildly different moral and ethical viewpoints. Another issue with sort of obtaining the standard is if you set the bar too high, then not enough conduct is considered dishonest. If you set the bar too low, too much conduct is considered dishonest. So there's almost a balance you have to find that is quite difficult to obtain. The subjective element has an issue with it as well, because if you have a defendant who has a particularly warped or poor understanding of behavior, then they might not themselves consider their conduct to be dishonest, adjudged to like an ordinary standard. So take both of those elements into account and give that to a jury, and then it becomes very difficult to apply. And juries have constantly found themselves struggling with both of these concepts, in fact. Another issue with dishonesty is the fact that dishonesty is the one element that separates an honest appropriation from theft. And you have to remember, when you convict someone, it's a major and serious event. So to then hinge that conviction on an element or an aspect of law that's very vague and ambiguous and difficult to apply, you start getting quite a few problems. And there have been calls to reform dishonesty. There have been calls to maybe scrap the subjective element. So, a defendant can't get away with a particularly poor or low level of understanding and replace it with a purely objective test. But as we've just discussed, that can also have problems as well. There are issues with appropriation in the sense that when we look at the law of robbery, which we'll actually cover in a later video, the appropriation or the assumption of rights in robbery is a continuing act, but in theft it happens once and only once. And there have been calls to maybe unify that aspect of appropriation to make it a bit more easier to understand and add some clarity to the law. Lastly, we also have issues with intention to permanently deprive. The reason being is if you've already dishonestly appropriated someone else's property, why do you then need the intention to permanently deprive? Surely the dishonesty alone should be enough, considering that in other areas of law, dishonesty is quite heavily punished. So those are just a few of the criticisms that I've come up with. But if you find anything else, please leave them in the comments below and I will look at them. But that sums up the topic of theft. We've covered the act of theft, the mental element, just done some of the criticisms now. But I can't wait to hear what you lot have to say. And please leave your comments in the comment section below. I will look at all of them. And hopefully we'll have more videos coming out soon. The next two topics should be robbery and burglary, just to sort of sum up this mini series on theft and theft related topics. But thank you for watching and I can't wait to see you around in future videos. Thank you very much.